This is David Fowler here, and I wanted to give you a quick update on the lawsuit that had been filed by opponents of Amendment 1, by the pro-choice crowd, to keep Amendment 1 from being adopted and added to our state constitution. The state attorney general last week on Friday filed a motion to dismiss the complaint. It's actually an excellent legal argument. The legal arguments are essentially those that we've talked about in the past, with the addition of one other argument. The first argument is that the plaintiffs lack standing. That's a legal term that simply means that the plaintiffs really haven't been injured in any particular or unique way different from any other person in the state. In other words, courts don't just hear complaints by citizens. You can't just go in and say, well, I don't like something, so the court needs to rule. You have to show that you have actually been injured in a way that's different from everybody else. And essentially, they're just arguing that you didn't count the votes right, which is an argument that's not unique to them, but to any citizen. So that argument was made very well. In addition, the Attorney General pointed out the history from the journals of past constitutional conventions showing exactly how the writers of our Constitution intended for the provision about half the votes in the governor's race to be counted, and showing that the plaintiff's argument is just contrary to what the framers intended by that language. Then the Attorney General goes on to point out that essentially this is a state issue. It is not even a federal issue. And lastly, and almost my favorite, is the argument that the plaintiff's position is actually unconstitutional because it is making my ability to vote on my Constitution contingent on taking some preconditioned step. In other words, you have to vote in the governor's race before you can vote on your own Constitution. And the Attorney General's argument is essentially that that's a precondition to voting on my Constitution. And in some ways, it's not unlike the old poll tax or literacy tax test that used to say you have to show that somehow you're qualified to be able to vote. So essentially, the Attorney General says their own argument would be unconstitutional. So I feel quite good about how the Attorney General is proceeding. I do believe that we will find ourselves victorious in this matter, and that the pendency of the lawsuit should in no way be a deterrent to the legislature proceeding to take action on informed consent laws, waiting periods, and clinic regulations when they reconvene in January. So stay tuned, and we'll keep you abreast of what happens in the lawsuit. Have a great Christmas.